We'd like to talk about school fights, be it either in high school or in college.
Junior high.
Yeah, as criminal defense attorneys, the world's changed as it relates to fighting in schools and kids under 18 or over 18. It doesn't matter anymore. Often these cases surface because you get a phone call from an administrator who's already talked to your kid and is trying to hone down on a punishment. But if somebody's been hurt, or badly hurt, you're certainly looking at potentially criminal charges. Even assault 4s I've seen filed now on low level disputes among kids. They're so risk adverse now. They want to refer everything over, and prosecutors are quick to file in these kinds of cases now. It's anti-bullying stuff.
Right, really. And the other issue you've got is recently happened up at Marysville Pilchuck. You had a 14-year-old kid walks in. He's the homecoming prince. He goes over to a table of his friends, pulls out a gun, and shoots 6 people, including himself. What do you do? Nobody knows what caused him to do that. Nobody knows why it happened. The problem is, it happened, and now you've got dead bodies and people trying to fight for their lives in the hospital.
Administrators now are have to respond great vigor on these kinds of cases. And what that means is immediately there are 2 things that go on if a criminal charge is going on. You've got the administrative action that's going to go on internally in the school, competing with the potential exposure to a criminal charge. And so the first thing I think families are coming in and talking to us about is, hey, what do we do? What's the command decision? We want to defend ourselves in the administrative process, and we want to make sure our kid doesn't get kicked out of school, or we don't want them to have a record in the administrative process that follows them up into other private schools and or college. But the command decision becomes, by answering to the administrative process, are you exposing yourself or locking yourself into a story in the criminal proceedings?
Yes, you are, because there's a case out there called King versus Olympic Pipeline. And in the criminal arena, if you've got a civil suit going and you've got a very definite chance that a criminal case is going to happen, you're not allowed to testify in the civil suit until the criminal case is resolved, because anything that you say in that civil deposition can and will be used against you in the criminal case. And that's where the problems begin, because those cases take years to resolve. And say you die in between. Well, if they don't have your statement, they don't have your statement. But if you opened up in a civil proceeding, now they've got something they can at least use to try and burn your firm with, or potentially burn you with, because you're dead.
And it's the same thing over and over again in criminal proceedings, that people don't realize that once you give a statement and it is the rules of evidence let it into a criminal case, you might as well have been Moses and chipped it into stone, because then your problem now is in front of a jury. You've already given a statement, and when you're trying to change that statement in front of a jury, their answer is,
are you lying now or are you lying then?
Yeah.
And that's what it boils down to. So what you need to do whenever you get notification that your child has been involved in an altercation at school, call us. Give us a shout, come in, we can sit down with you, we can run over the facts, we can let you know what your exposure is on what different levels, and then you can make the decision as to whether or not you want to hire us, because ultimately you don't want your kid going to a different school. You don't want them expelled from a school district.
Or criminal charge.
Or criminal charges.
Actually, I think even more important at that point is for people to realize that school administrators and police can interview your sub-18-year-old child or over 18-year-old child without your presence, whether they're a dependent or not. We have a lot of people coming in furious about that, not realizing, hey, they can talk to them. So if you have your kid's cell phone number, or you can drive down and talk to your kid right away and say, as a policy, our family does not talk to people until we've talked to a lawyer first. Kids don't know. This is one of those things, like, until you're exposed to it. We've been exposed to it
a number of times.
Yeah.
And the thing that you got to realize is that the parents cannot exercise their child's Fifth Amendment right to remain silent, because case law says you can't do it. The kid has to look at the cops and go, I want a lawyer.
Which is kind of absurd, right?
It's totally
like
absurd. Kids have no idea what the hell's going on.
Yeah, how often the 16-year-old you can put pressure as a parent on a child to get them to give up information
and crack,
and let alone a professionally trained police officer or
you got to realize police are trained
power
to interview kids. They're trained to interview everybody, but with kids it's a whole different ballgame, because kids are not old enough or shouldn't be old enough to have developed the type of defense mechanisms that adults have. And if they have, that shows there's some issues at home. But more importantly, it shows that the cops know that if they can get to this kid early, they can probably get a much different result on this than if they can't.
Yeah, because they're just looking for facts, right? Why are they looking for facts? Because their job is to prove cases beyond a reasonable doubt and collect probable cause. That's it. That's all they do.
And in our experience, say your son or daughter was the aggressor. They came out and they just cold cocked somebody. They may have had a valid reason. It could have been defense of themselves, defense of others, defense of property, or maybe they were just so agitated they're like, I'm tired of taking this crap from this kid, and cold cock.
It's a bullying issue.
Yeah, at that point in time, we can get your kids into counseling. We can get them into an evaluation. We can have them engage in programs that by the time this case actually hits a school board hearing and or the court system, we can hopefully get it dropped, because it's like, issue's been addressed, issue's been resolved.
A lot of things you can do up front, but it requires us to talk to you about it. And we have an enormous amount of wisdom and experience relating to criminal charges in general. And so you're kind of like, it wouldn't make sense to go in and try your own case because you've never been in a courtroom before, you never talked in front of a jury, etc. And if this is your first run-in with a school board hearing, same policy I think should apply.
Yep. Give us a call if you have some issues with school fights or agitations, because we can help you out.
Thank you.